Isaac Ellington.
Assistant Public Defender Constable Bissey on behalf of Isaac Ellington. Mr. Ellington, could you unmute and state your full name, please?
Isaac Ellington.
Mr. Ellington, did you get a chance to review the PSI that I sent you, your email?
Yes. Yes.
Are there any corrections that you want to address?
Yes. A committed correction. I was never doing drugs. I got a friend, high school friend of mine. I've been trying to stop him for him doing drugs. Hold on. Stop him for doing drugs and taking the drugs from him. And the next couple of days, he passed away. I've been clean. I was dropped yesterday. I've been negative. I've been clean. I just lost a good friend of mine of the drugs, and he never woke up, and that's why I got the positive. I've been taking.
So you're saying you didn't do drugs?
No, I didn't do drugs. I didn't do drugs, and I got one positive in April, and another one. I've been.
So you're saying positive for cocaine, aren't you?
No, that's not. It's me because I'm taking it from my friend. He passed away now a couple days ago.
You took it from your friend, and then how did it get into your system?
It probably because I touched it. That's the difference if you use it.
Oh.
And I'm taking it from
so you touched the cocaine, and then you tested positive.
Yes. Then I was negative.
Okay, is that the story? Is that really the story you're going to go with?
Yes.
You want to talk to your attorney before you stick with that story?
Yes, for real. I've been honest.
But do you want to talk to your attorney before that's the story you're giving me? Because this recommendation will change.
Mr. Ellington, I would advise you to accept what the recommendation is saying and ask the court to adopt that recommendation.
How about this cocaine, though? Because he's telling me that he didn't do it.
I would just ask the court to disregard Mr. Ellington's previous statement.
Well, I can't disregard it. That's like unringing a bell. I heard him.
Jim Simpson, I'm honest. I've been coming to court. I've been doing everything.
I know you're honest, but not an amoeba. You don't absorb things that way. So, counsel, you don't really do this, but you want me to give you a breakout room to talk with him?
Yes,
and then we can talk about how the cocaine got there?
Oh, my God.
Yes, please.
Yeah, I know.
Okay. Joe Simpson, I'm being honest. My friend is
Sir,
Mr. Ellington.
Sir, I don't doubt that part. I doubt the other part you just told me. Because, and I'm just going to lay it out there, you had a positive for methamphetamines on March 23rd. March 28th, you're positive, hold on, you're positive for cocaine. You go away, you do have a negative test in between them, come back April 3rd, you're positive for cocaine again. So, and he didn't go to the CCOP program. So this may change in any event. Sir, I'm just going to ask you, do you want to go into a breakout room and discuss this with your attorney prior to the court proceeding forward with sentencing? Because I'm ready to go, but I don't know that you are.
Okay, Simpson.
So why don't we do this? Counsel, do you have Mr. Williams, is that yours? Yeah, I know. I see you, Mr. Williams. I just want to make sure. Q, do you have Mr. Williams or no?
No.
That's yours?
That's mine.
Oh, okay. I got you. So let's put Kasim and the amazing Mr. Ellington into a breakout room, and then we can bring them back momentarily. All right. Take care, guys. We'll see you in a bit. Isaac Ellington.
Yes, Assistant Public Defender Constable Basie on behalf of Isaac Ellington. Mr. Ellington, could you unmute, please? Say your name again.
Isaac Ellington.
Once again, Your Honor, we have reviewed the PSI, and Mr. Ellington does not have any. He would like the court to adopt the recommendation. Mr. Ellington, would you like to go ahead?
Yes.
Okay, so what about the cocaine? I'll wait.
I was just helping my friend out. I did it once or twice, Your Honor.
You did what?
I did it once or twice, Your Honor.
So you actually ingested the cocaine?
Yes, Your Honor.
Yeah. That's a much better story than the first one you gave me. Sent to the court, 12 months probation, $655 fines and court costs, $360 probation oversight fees. When can you pay that?
I can pay $75 April 21st before I get paid.
You can pay what?
$75. Next week I get paid.
He expressed to me that he would like to get on a payment plan if possible, Your
Yes.
Honor.
Yes.
Pay $75. Well, just a probation payment plan. There's to be no use of alcohol, recreational marijuana, or any illegal substance. You'll be subject to random testing as requested by probation. You know what? No, he's going to continue on his testing. Yeah.
I will be clean. I swear on it.
Well, here's what we're going to do.
No more.
You know, I hear you. So I'm going to give you a chance to prove yourself to me.
Okay.
Ms. Valera, I want him on testing, random testing through community corrections for the next 60 days. You're to complete the CCOP program or a comparable program. Now, when you do that testing, I'm just going to let you know. Any positives, you might as well just prepare for jail time. That's how I'm going to work this. I don't like people not telling me the truth, and you tried to start out not telling me the truth.
Okay, Your Honor.
You're to maintain employment with proof to probation. I'll order 365 days in jail. Credit 2. Defendant will serve an additional 5 days for the bond violations to date, and then the balance will be suspended. You are ordered to report to the Washington County Jail by 6 p.m. So I got 360 other reasons why you don't want to use. We clear?
Yes.
Thank you. Report to the jail by 6 p.m. or a bench warrant will issue with no bond.
Your Honor. Okay.
What? What do you want to tell me?
I was gonna tell you, can I do it Friday? I could tell my job to hold my job and tell my kid I won't be gone for 5 days.
You know what, Mr. Ellington, I would have been more than happy to do that. But the problem is you came to me lying to me. I don't know right now whether hold on. I don't know whether or not you're telling me the truth right now.
I am telling the truth because I'm at my
So
job.
the problem, Mr. Ellington, is when you start out like that, I can't trust you. I can't trust you that you'll be there Friday. I can't even trust that you're going to be there tonight. But I can tell you, if you're not there tonight, what's going to end up happening, I'm going to send somebody out to get you.
I'm going to be there Friday, I promise.
6 p.m. Thank you.
Your Honor, I would just like to say that Mr. Ellington has expressed to me how concerned he is about keeping his job, and since him keeping his job is part of PSI's recommendation, I mean, if we could just get a day, possibly, or two, and then have him report maybe by 6 p.m. tomorrow before the warrant goes out. Just to give him a small cushion to get his job straightened out.
No, not doing it. I told you what I'm doing. He did what he did. Now I'm gonna do what I'm gonna do. That's just the way it works with me.
I will be there. I'm sorry.
And counsel, if somebody had come to me and said, "Yeah, I accidentally used, or I shouldn't have used, I did this," then I'll deal with that. But if you come to me just straight up lying, and I'm telling you, I don't believe your story, and you continue to lie, and then I got to put you into a breakout room with your attorney, and now you're going to come back and tell me the truth? Really? And now you want me to do something for you? Don't think so. I'm done.
I'm not lying.
I'm done. All right, am I back? I'm green.
Okay.
I'm live. Okay. My apologies, folks.
It's okay, Mr.
Just
Simpson.
not one of those days. Court calls the case, People versus DeMario Farrell.
Caitlin Kirby on behalf of the people.
DeMario Farrell,
Did you call me? I can't hear the volume up.
Assistant Public Defender Constable Basie on behalf of DeMario Farrell. Mr. Farrell, can you please state your full name?
DeMario Farrell.
What are we doing on this case? Because we have to deal with some bond issues.
Yes, Your Honor. I would let the defender go first as to what he wants to do on the matter, and then I'd like to address bond.
Hello?
Hello?
Yeah, my volume is real low, but it's all the way to the top.
Okay. Well, you will hear me soon.
Okay.
You? What are we doing?
It looks like he has some violations the prosecution wants to address, Your Honor. I have not had a chance to speak with him about it. I tried to reach out to him by email and phone, and I have not been able to. Mr. Farrell, did you update the court with a phone number that works?
Yeah, I gave him my personal cell phone number. I never received a call or nothing or no email. I've been.
You go ahead and give me that number once we get done.
Because you guys haven't had any contact at some point, then I'll adjourn the matter at some point, but there's something that we have to deal with before then. Ms. Kirby.
Yes, Your Honor. It came to my attention through the victim advocate. The victim sent her some screenshots of text messages that they're stated from Rio, which is my understanding is the defendant DeMario Farrell. He is supposed to have a no contact order with the victim. I did send these to the public defender as well as the court. He's basically there's obviously no contact, and there's numerous text messages throughout all these screenshots. There's some of the messages indicate that she's playing dumb and putting him into a situation where he did nothing wrong. So I have concerns about his ability to follow the court orders and take the court system seriously. About the violations. It doesn't appear that he's actually going anywhere, so I don't know that a GPS tracker would actually help him not contact the victim. So I believe that it would be appropriate for bond to be revoked, given the fact that he was arraigned and told of this no contact order, as well as the text messages are not just from one day or one time. These are numerous messages in a row.
Your Honor, that's because we have a child together, and I didn't understand that the no contact mean that I can't reach out.
Well, Mr. Farrell, I think you might want to talk to your attorney before you say anything else.
Okay.
Because, and I'll just say this, that when I'm looking through these don't necessarily have, not all of this has to do with that child. So before I make a decision on the revocation of bond, counsel, do you want to speak to him in a breakout room?
Please.
Can I get my volume turned up, please?
Do what?
My volume is like extra low.
Okay, you can call him if you want, but I'm going to put your screen and his screen into a breakout room.
All right.
Thank you. I'll pass it. Court recalls the case, People versus Demario Farrell.
Caitlin Kirby on behalf of the people.
Assistant Public Defender Cosimo Bessi on behalf of Mario Farrell. Your Honor, I have had a chance to speak with Mr. Farrell. I thoroughly re-explained to him in terms of his bond, and I made it clear to him any confusion that he had. He expressed to me that he didn't fully understand the terms of the no contact, and due to the non-threatening nature of the contact that he made, we would ask for some leniency from the court, perhaps, as well as the fact that his ultimate goal was to figure out what was going on with his child, Your Honor, and that's it. He was not trying to make any physical contact with her. He has maintained his distance. He has not been trying to see her. He simply misunderstood the terms of his contact regarding his child, Your Honor. And like I said, I have thoroughly went over those with him, and now he knows. He clearly understands the terms of his bond and what no contact means.
And Your Honor, if I may respond.
Yes.
While I agree that they're not necessarily threatening, they're definitely harassing. These text messages are coming in at numerous times of the day, including 4:47 a.m. Some of them are at 8 p.m. I believe there's only a few that actually relate to his child directly. There's one in particular that says, "You don't have to put me in jail to go be free whenever you want to be done with somebody. Just tell them that." That has nothing to do with their child. The next one says, "I would never think about putting you behind bars, and it's been times I could have, but for what?" This is actually like bordering witness interference. These are harassing communications. So whether he is saying they were just for his child, or if he knew or not knew, the magistrate does go over the domestic violence terms at every arraignment. He does have an attorney. He was able to ask them if he could contact the victim and or not about their child. And I just have concerns that these texts they're not stopping. So it's not a once how is our child doing? Is she doing okay in school? There's also a text message that says, "You could have told me you not effing with me like that, but I knew I should have listened to mine first when I was gone." And it continues. There's some profanity in there and slurs. So I mean, this is just inappropriate conversation, especially since his excuse is that it's all about their child, which I don't believe that's true.
Wow. Your Honor, I would also like to make a response to that. There are numerous requests for him to speak to his child. There are numerous apologies, and as well as a text message that says, "I'm not trying to feud with anybody anymore." He's repeatedly apologized. Can I at least talk to her more than once? So, like I said, the ultimate goal is for him to try to speak with his child and figure out what was going on with his child. And like I said, the text messages include numerous apologies. They're not any type of violent conduct or any type of threats made. So I just wanted to address that.
Well, not direct, but what is it about these? There's actually audio calls instead of type messages.
I was trying to read. Oh, sorry.
Mr. Farrell, I'll handle it.
I mean, I've got missed audio calls from him to her.
She's wrong.
April 5th at 3:55 p.m., April 5th at 9:54 p.m., April 6th at 11:44 a.m., April 8th, 9:45 a.m., and then there's another one that doesn't have a date or it's cut off. Then April 8th at 10:07 a.m. I just think when I look at these, I mean, that's a problem. He's not supposed to be having any contact. If there's a child involved, then there's a mechanism by which he can go through to deal with that. And had he contacted you, but these are numerous contacts, sort of over and over. There's a missed audio call. He doesn't call, doesn't call her back. And he just keeps going. Time and time again. And just doesn't seem to understand not only the court's conditions, but if somebody's not responding, then they're not responding.
I haven't contacted her since. I'm not into that lose Kamaya like this, bro. This is crazy. But you
That's
see
the
what
problem.
you do. That's all you should do best. Don't just put up daddy. It's your daughter too.
You can see he's deeply concerned for his daughter, Your Honor, and I understand, and I made it very clear to him going forward what the conditions of no contact.
Yes, you did. And man, this is frustrating. Can I talk to him? I don't know if you can do that. Excuse me, sir. I don't know if I'm even supposed to be talking.
Mr. Farrell, if you'd like to speak, you just mute yourself.
Can I?
I'll set a bond.
Say nothing.
Is he done?
Yeah, he's done, Your Honor.
I'll set a bond hearing for April 24th, 2023, 9 a.m. Mainly to go through how this can't or shouldn't occur before. But at this time, given what I see here, the defendant's bond is hereby ordered revoked. Defendant to report to the Washtenaw County Jail by 6 p.m. this evening.
Excuse me, sir.
And that hearing on the 24th is in person.
Your Honor, may I say something?
If you'd like.
I'm not even in the state of Michigan. Like, how would I be able to just report myself to jail like that? That's what I'm trying to get you to understand. Like, I'm not, like, I fully understand the terms of no contact now that he went over with me, but I'm miles away from there. Like, I'm just been reaching out there because my daughter came to the state of Michigan with me. She was in my possession. And all this happened. You know what I'm saying? I was up there to help her get on her feet. And boom, she called the police out of misunderstanding. If you look at the body cam on your officers that arrested me,
You might
I'm
want to
Mr.
stop
Farrell,
him.
Mr. Farrell, please just refrain from speaking about anything more that happened that day.
What state is he in?
Where are you currently?
I'm in Georgia.
And Your Honor, I don't see anything from the arraignment where he is supposed to be in Georgia. My notes say that he was given PR here, and then he was taken to Wayne County and served 30 days in jail. And the magistrate explained that he had the no contact and no go-to order still in place. And I'm looking in GIS, and I don't see anything about his residence being in Georgia.
That's what my current ID when they arrested me says Georgia. My ID and my property says
Sir, Mr. Farrell, maybe you didn't understand what the magistrate was telling you. If you want to keep interrupting me, you can keep interrupting me, but I'm about to tell you something, because part of your bond conditions are you are not to leave the state of Michigan without permission of the court. And when you said you weren't in the state, I'm looking through the file, the actual paper part of the file, to try and determine whether or not anybody granted you permission to leave the state. And I don't see it. I don't see it in terms of any paperwork, and I also don't see it in terms of any. There's no order which allows you to leave the state.
Man.
Well, here's what I'm going to do. I'm going to set he's got violations all over the place. He's got no contact violations. He's left the state without the permission of the court. I'm going to set the bond hearing for the time and date that I said of April 24th, 2023, 9 a.m. That will be in person. I'm going to give the defendant 2 days to report to the Washington County Jail. What's Wednesday?
Wednesday is the 19th.
I'll give him until the 19th, presuming that he doesn't. I don't know how you misunderstand that order. April 19th, or a bench warrant will issue with no bond.
Can am I allowed to say that's
Yes.
no?
Judge, I'm so sorry. What time? By what time on the 19th?
By 6 p.m. on the 19th.
Thank you,
I'll
Judge.
give him. Okay. He shouldn't have, and I'm sure counsel explained to him, he shouldn't have left the state. He shouldn't have been contacting her. Shouldn't have been doing a lot of things that are in this. And the magistrate told him there's a signed order to that effect, and then just wants to do it his way. Well, now we'll do it my way. Thank you.
What?